my gratitude for this opportunity, of course, for the co-organizers and the organizers, and also the members of the research group for their contribution to this research. It was a great honor for me to try to somehow summarize and somehow lead this group. Some general remarks for this presentation. First of all, this project connected to the Professor Network project, which at this moment has 5 research groups. That is, or as to these research groups, one of our goals is to publish a kind of book concerning dealing with this issue, the constitutional protection of future generations and the environment. In order that, we would like to define our specific Central European approach to the topic. It's obvious that environmental problems is not only a Central European problem, and it's also apparent that this region has its history concerning environmental protection. One of our members in his presentation mentioned that his or her country, after the Stockholm Conference, adopted its general environmental protection rules, and that was the situation also in Hungary, that we had a quite early general act. That is, this environmental protection problem is also a problem of the Central Europe, and I think that it's not good if we try only to accept the modern environmental protection policies of other regions, but we should try to somehow determine our problems and to find our solutions. Maybe some of them it's specific, maybe some of them of course general, but it's quite important aspect of this analysis. Here you can see the system of the book, conceptual topics. The author is Professor Bandi, international aspects, and of course national situations in 8 countries. Here you can see the countries themselves denominated. The first thing as to this presentation, that the book chapters are not finalized. It means that for the present assessment, the present presentation can only be considered as a provisional observations. Maybe in the second part of the year I will present something different from this presentation. The present assessment, however, was based on 7 countries chapters. That is, in this presentation I did not deal with Romania, but of course in the book and in the final conclusion I will also deal with Romania. That is the maybe most important issues of the comparison of this research, especially to the national chapters of the book. In their presentations, our members, some of them presented all of these issues, or almost all of these issues. Some of them focused only one or two or some moments of these aspects. However, that is the most interesting part. And now I would like to start with the constitutional definition of concepts of these issues. First of all, environment, whether is it mentioned, it's typical that it's mentioned. However, we cannot find typically the definition or the concept of this environment in the Constitution. There is an exception, that is Croatia. Natural resources. The special protection of natural resources is stipulated almost in all constitutions except Poland. The concept however, it is exemplificative in some countries' constitution. Here you can see the countries. And in some constitutions, there are specific rules also for separate components as well. Future generations, they are mentioned in 4 constitutions from 7. I think it can be quite interesting that, for example, in Hungarian constitution, the future Hungarians also denominated. In the CC's practice, there is only indirect reference to the concept of future generation. Therefore the question, what does it mean exactly? I would like to emphasize that, of course, we have international documents. Maybe we can say that they are part of the soft law of the international law or level. But it's worth noticing that in a constitution, in a national constitution, we are not forced to accept a kind of international definition. But the question is what, for example, Constitutional Court thought of this issue. It is an open question at this moment for me. In the constitutions, they are connected to responsibility, typically, or protection of natural resources, or sustainable budget management, or ecological security, or heritage. It can be interesting as well. Sustainable development, it's mentioned in 3 constitutions, and the aspects which related to this issue, also budget management, foreign affairs, sustainable natural environment, national assets, regional development, or other tasks. As to the role of given constitutional actors, of course, besides parliament, governments, and so on and so on, constitutional courts. In some countries, its role is significant. It was obvious for me, for example, in Hungary, Poland, but for example, our Slovenian colleague mentioned that in their country, the Constitutional Court also has an important role. In numerous countries, it is only a so-called court of law. However, in my opinion, in Hungary, it has also a little bit of court of fact aspect in connection with environmental issues, for example, to prove the level, the present level, of the protection of environment, and whether a measure it is below or above this level. Ombudsman. It's typical that in a country there is a kind of ombudsman, a kind of general ombudsman, but it's quite specific in Hungary that we have a specific deputy ombudsman established by the constitution, especially for the protection of future generation. Their competence, however, typically focuses on public actors, national, regional, and local actors. Another interesting actor can be the president of a state. Some of them are active. Our Czech colleague also mentioned President from Czechia. The situation was same in Hungary. My young colleague Nico Krajniak mentioned some important Constitutional Court decisions. Some of them was also supported by the President of Hungary. The 2015 or 2018 constitutional judgment. I think it's an important message for us. As to human rights, of course, the core right can be the right to a healthy environment. In 5 countries' constitution, it is regulated with this name or a similar name. That is the situation in Czechia and in Slovakia, that they apply the right to a favorable environment. However, our members assess it as a synonym to the right to a healthy environment. In Slovenia, the right to a healthy living environment is mentioned, and our colleague from Slovenia assessed the situation that is not less than, for example, the typical right to a healthy environment. However, in Croatia, the situation is quite interesting with the right to a healthy life. Our professor mentioned it's not the right to life, and it's not the same as the right to a healthy environment, something between these categories. In some countries, the Constitutional Court's and Ombudsman's practice is quite significant to interpret this right. That was the situation, for example, in Hungary. In our country, the non-derogation principle and precautionary principle is developed by the Constitutional Court as a hard principles, maybe by which the Constitutional Court is able to terminate a kind of act. As to human rights, other rights related to the right to a healthy environment or protection of the environment, you can see that the interconnections among these human rights, it's so colorful. Expresses where these connections to the environment can be found in connection with right to information, right to health, right to drinking water, right to healthy life, and also there are numerous interactions denominated by the Constitutional Court's practice. Here you can see the list of these rights. Maybe after my presentation there will be a critique that human dignity was not mentioned on the table. Another interesting aspect, of course, that human rights subject to restrictions with reference to the environment. A quite interesting issue connected to Poland, that is, in a general sense, human rights can be restricted to reference to the environment protection. It's typical that this restriction regulated in connection with the right to property or free enterprise and proprietary rights, freedom of movement and residence. And, of course, the Constitutional Court's practice is also active in connection with this topic. Protection of the environment as a task is almost obvious that as a state task is stipulated in the Constitution. In some countries there are other state tasks relevant for the environment, for example in Hungary, the GMO agriculture, access to drinking water, and so on and so on. In all countries, constitutions and or constitutional practice, it is defined as an obligation for citizens as well. And in all countries, constitutions or constitutional practice, it is defined as an obligation for other actors. Our conclusion is including, for example, multi-companies as well. As to liability and the polluter pays principle, it's typical that compensation for environmental damage is stipulated in the constitutions or in the constitutional practice, typically referring to anyone, everyone, state, provinces and persons. Therefore it's typical that they use a kind of general obligations, not only for state but for other actors as well. There was a question whether the constitutions or the constitutional practice stipulate the polluter user pays principle. The situation is quite clear in Poland. We can say that it is partially regulated in Slovenia and partially, in my opinion, not, of course. And I know that that is your opinion as well. However, we cannot annoy, for example, the special opinion of a judge of the Constitutional Court, or, for example, the previous Ombudsman of future generation, who, when assessed the new fundamental law, he expressed that issue that somehow he could interpret the Hungarian rules as polluter pays principle. Sorry. That is the situation that would arguably maybe, and it's, yeah, okay. The other relevant values in the Constitution, from a Hungarian point of view, it was obvious why we tried to analyze this issue, because as previously mentioned, in the Hungarian Constitution you can find that Christian culture is protected by the Constitution, and it's obvious that the churches, Christian churches, they are active and they are devoted to the protection of the environment. Therefore, it was a good opportunity to assess this issue in other countries as well. Another interesting issue connected to a core problem of the environmental protection, that is the population. The increasing population all around the world, but in Central Europe we have another characteristic, that is decreasing number of the population. Therefore, for me, it was a quite interesting issue. What is our position? Can we read something message in connection with this issue from the national constitution? Therefore, my question was whether a link between the present and future generation is regulated in the constitution or not. Here you can see these potential links, encouragement of maternity or parenthood, which was typical in the constitution. However, there was a special rule in the Slovenian constitution which also encouraged the maternity, but previously it is emphasized that freedom of people, whether to give birth for a child or not, is also part of the constitution. Another interesting issue that, as you know, the future generation, this category was adopted by the Brundtland Commission, and it was at the end of the 80s, and nowadays the future generation, they are present generations, and the question, maybe we should also deal with this issue that the environmental problems increased. The activity to avoid the negative effect of our modern civilization, it was not as successful. Maybe we have to somehow reinterpret the category of future generation, and it's not a unique thing, because in numerous cases we can see that the future generation means not only unborn generations, but maybe already born generations. And another interesting issue, the connection between this generation, the transitional generations. It is a category, created by me, how to provide, this issue, maybe through the protection of children. It's an open issue, it's not something fixed or closed issue. I'm absolutely curious what is your opinion, whether is it an important factor in this topic or not. That was the reason why I asked my members of the group to deal with this issue in your chapter. And the Lega Ferenda is first emphasizing that it's a quite important goal of our research to present good practices. If we can find in our country's constitution or constitutional practice, it is a good opportunity to do that. Now you cannot see, these good practices on my slide, but I hope that in the book we can present them. And another important goal of this research, to provide the Lega Ferenda proposals how to modify the rules or the practice. It's worth noticing that there is not a compulsory obligation in law that, for example, a state is forced to put right to a healthy environment in its constitution. There is not a compulsory issue or to apply right to information, specific right to information in connection with environment. The states, in my opinion, they have a quite great freedom how to solve environmental problems via law, legal order. But in my opinion, this can be a good opportunity, to put into this high-level document, high-level law, these issues. Therefore, I do not want to criticize, for example, national constitution, that why do you not have, special right to a healthy environment in your constitution, but maybe it can be a conclusion and an opportunity for us to somehow protect at a higher level, the interests of future generation. However, the Lega Ferenda proposals, only as an examples, I can feel a kind of opportunity in rethinking the definitions of environment, maybe natural resource, future generations, and their interest and needs in constitution and in CC practice. I would like to emphasize that numerous constitutional courts have not applied this opportunity, to detail these issues, but I think it is their freedom to do that, and to do that in a specific way, maybe in a specific way, taking into account our national, regional characteristic. Reinterpreting the relationships and/or borders among the different generations, taking into account, among other, the specific demographic challenges of the Central European region. It's also a quite good opportunity to do that. Or redefining of the competence of specific actors, for example, Constitutional Court, Ombudsman's President. In my opinion, this quite active role of the Hungarian Constitutional Court is connected to this special aspect of its characteristic that is a kind of court of facts. Maybe it can be interesting for others as well. Or it's typical that ombudsman activity connected to the public actors, but maybe we could open this competence of the ombudsman activity in connection with private actors, also in international level. Another interesting issue, which was inspired, of course, of this research, that reassessing the links among different human rights connected to the protection of future generations and the environment. As you could see, there are so many human rights connected to this issue, assessed by the Constitutional Court, or they are denominated in the constitutions, national constitutions. Therefore, these interactions, maybe they also provide new opportunities, taking into account the future challenges or the present ones. Another interesting opportunity I can see in involving other constitutional values, for example, as to Hungarian constitution, the Christian heritage, the Christian culture, to interpret, the classic environmental rules. Of course, there are other potential values in different national constitutions which can be interesting for us. Or establishing financial sustainability for the interest of the future generation. That is the situation, for example, in Hungary. Or thinking of the rules of special legal order in connection with environmental challenges. Special legal order, I think it's obvious after the pandemic. There are typical issues connected, for example, to wars and nowadays pandemic. But environmental challenges, they can maybe also inspire present or later amendments. For example, which can be found in the 19th Amendment of the Hungarian Constitution. Ninth Amendment. Yeah, I'm only out of the future. Sorry. Another interesting issue connected to the polluter pays principle, and now I try to focus on constitutional level. What does it mean, polluter pays principle at constitutional level? Who knows? However, it's worth noticing that in numerous cases, when we speak of polluter pays principle, I can feel that the decision maker, who is that, try to establish a kind of financial obligation to a low level user of the environment. And in my opinion, somehow we should strengthen similar obligations in connection with the system managers. Because it's easy to make a tax, for example, and to ask the consumers to pay this, but sometimes it's not so easy, for these consumers to change the system itself, especially if these systems connected to international level. Therefore, I can see numerous opportunities how to calculate, how to use the outcomes of this research, and I hope that at the end of this project maybe we can provide more specific or more interesting opportunities for our audience. Dear colleagues, thank you so much for your attention. This reference typically connected to Einstein. Who knows? Their colleagues, their contributors, their audience. Thank you so much for your presence and activity. It's worth noticing that as to the members of the research group, we have a discussion, but not now, but tomorrow, because we have a workshop tomorrow here in Péter Catholic University. If in that room, yes, but we have to reach this auditorium from another point of the building, from this main entrance, but another part. Therefore, thank you so much, and I have all the opportunity to close the conference now. Thank you so much.